Hello and welcome. I am Camille Cooper, the Vice President of Public Policy at RAINN. It is my pleasure to welcome our audience to this panel discussion about the dire need for federal and state policy reforms for the family courts across the United States. According to a recently published study involving abuse cases in the family court context, courts credited claims of abuse perpetrated by fathers in only 2% of cases where alienation was raised as a defense. Also, according to the Leadership Council on Child Abuse and Interpersonal Violence, at least 58,000 abused children each year are being court-ordered into unsupervised contact or custody with a parent that they've alleged is abusing them. In most cases, the children's disclosures are not believed, and the protective parent is viewed by the court as vindictive. The Allen v. Farrow documentary is a stark example of how children's disclosures of abuse are handled by the family court in that context. Dylan Farrow joins us today, and her case is significant in that Dylan's judge in her case protected Dylan from further contact with her abuser. But despite that, Dylan and her entire family were impacted by the attempts of her abuser to discredit her disclosures by claiming that she had been alienated or coached. Today, we will be discussing efforts at the federal and state level to reform the family courts to prioritize child safety, to hold judges accountable, and to collect data about the problem so that new policies can be crafted to deal with this child safety crisis in the family court system. I would now like to introduce our very distinguished panelists. You can read their full bios on the website. Lynn Rosenthal was appointed as the first ever White House advisor on violence against women under the Obama administration and has been a career advocate for ending domestic violence. Senator Dave Min is with us today. He's a California state senator from Orange County who recently authored Senate Bill 654 to better protect children during unsupervised visitation. Dylan Farrow is with us today. She is a child sexual abuse survivor, an author, a mother, and her story is the subject of the Allen v. Farrow HBO miniseries. Kathleen Russell is the founding executive director of the Center for Judicial Excellence, a national nonprofit focused on increasing judicial accountability and protecting children in family courts. Dylan, thank you for joining us today. Our first question goes out to you. And now that you've had some time to reflect on what happened to you and you're sort of seeing it as an adult, and how your case was handled by the system, what do you believe are the most important and pressing changes that need to be made to how the system handles cases like yours?
Where do I start? It's one of those questions that's a little bit twofold, I feel like, because on the one hand, I have been told that a lot of great changes have been made already, including that children are not required to testify, or they're not called in 9 times to disclose over and over again. They're, brought to a safe environment and they disclose once. They aren't made to take the stand and face their abuser in court, which was the whole reason why my case was not brought to the criminal court. The measures have been taken to not traumatize children as much as I had been. On the other hand, hearing that there are still kids who are going back to their abusers nonetheless is incredibly, incredibly disturbing, and why it's so important that there are, measures to be taken to protect them. I think that, I'm not really in a position to, talk about the law or anything. I'm not a lawyer. I'm not a politician. I can't really enact any of these big changes, but speaking personally as somebody who was affected by these circumstances, I think across the board, what needs to happen is that survivors of sexual assault should not be punished more rigorously than perpetrators. And judges like Elliot Wilk need to be the rule and not the exception. people pushing for change in these areas need to not be outliers. They need to be at the forefront, like Senator Min, which is why I appreciate what you've done so much. I think we've come a long way, but there's a long way still to go. And I think that as activists, we need to sort of take the long view on these issues.
Yeah, thank you. And I feel like your bravery and sort of addressing these issues in a public forum has been incredibly inspiring to so many survivors that have experienced the same type of circumstances. So I just want to thank you for doing that and sort of leading the way and giving a voice to thousands of voiceless children. So thank you for doing that. Kathleen, you've worked to pass legislation both at the state and federal level to protect kids in family courts. And you've been working for years, I think maybe even decades on this issue. Can you describe the family court crisis for our audience and for policy staffers who may not be familiar with this crisis?
Sure, Camille, and it's wonderful to be on this panel with everyone. As mentioned, 58,000 kids annually in the US are being court ordered into abusive contact with a parent they've reported is abusing them. This crisis has been going on for decades. That's over 1 million children in the US in the last 20 years, just to put it in context nationally. Research being done at our center also shows more than 800 children in the US have been murdered by a divorcing or separating parent since 2008. Many of these preventable homicides, if family courts hadn't dismissed the evidence of violence and the lethality before the murders. I know Lynn met 2 of these mothers back in 2011 when she was at the White House, Katie Tagle and Amy Lichtenberg. And since then, this problem continues. You see it in the headlines. Numerous states are passing laws in honor of these deceased children. Peaky's resolution in California, Kira's law in New York, Colton's law in Illinois, and Caden's law in Pennsylvania, and now in the House passed version of VAWA. Episode 3 of the incredible series, Allen v. Farrow, talks a lot about alienation. We're seeing now rampant spread of these court-ordered, unregulated threat therapy camps, which are being sold to judges as the last resort for kids who are being labeled by experts as alienated because they resist spending time with abusers. The camps are essentially profit centers for psychologists who are running them. Judges switch custody to the abusive parent. The kids are shipped against their will to motel rooms with their abusers. They're threatened they'll never see the parent who's protected them their whole life unless they renounce their abuse and cooperate. And they're told their safe parent often will be sent to prison. Costly aftercare is ordered. Parents are forced to pay for all of it, with one couple in California even ordered by a judge to raid their daughter's college fund to pay for this abusive and unscientific treatment. So I share that as just an example of how far afield things have gotten. Even outside of these camps, middle-class parents are becoming low income. Low-income parents are becoming homeless. What most don't realize is that divorcing or separating couples are quite literally being pushed into poverty by the family court system, forced to spend everything they and their extended families have on psychologists, attorneys for the children, guardian ad litem, special masters, costly expert witnesses. The fees that these folks charge parents are not regulated, and courts coerce them onto it. It's like a hamster wheel that they can't get off. It's really a multi-billion-dollar industry, which makes its reform that much more challenging. The courts are systematically depleting parents of their money and assets, which really makes appeals in these cases nearly impossible for most Americans. And just to give you an idea, in California, 90% of litigants have no money for an attorney and go into these cases unrepresented. It's really an unlevel playing field if you have no attorney and the abusive parent has an attorney. So DV survivors go into court thinking they've got the evidence they need to protect their kids. They've got police reports, medical records, often criminal history, and sometimes even confessions of abuse from the perpetrator, but judges are being trained that abuse allegations are always alienation. And the 2012 DOJ Commission Saunders study showed that key decision makers in a case, these are the judges, the custody evaluators, and attorneys, were least likely to believe the domestic violence and child sexual abuse occurred. And they're most likely to believe that these are false allegations. And again, false allegations is rare in these particularly child sex abuse cases, according to the bulk of research in our field. And yet those are the cases, unlike Dylan's, where she was very lucky, most child sex abuse cases end up with the child not protected. So it's a cultural problem in family courts, and until the culture is fixed, things are not going to change. So we need to start, in our view, with making judges and court appointees in these cases accountable.
It sounds like by your description that we have a sort of culture of denial within the system itself, that you have a lot of people that are responsible for the actual protection of these children that suffer from denying that this type of abuse is as endemic as it actually is. So that's, some of that information is really concerning. I did see Lynn, during Kathleen talking, I saw you nodding your head yes a lot. I know that you've worked on these issues for decades. You served as the first ever White House advisor on the violence against women under President Obama and then President Joseph Biden. Can you talk about your work during that time and since then to address this issue of how family courts are handling these cases of domestic violence and child sexual abuse that arise between either never married, divorcing, or separating parents?
Thank you, Camille, and thank you for having me. And I wanted to say, Dylan, I was struck by what you said. You are an expert and you are bringing about change. So you don't have to be a lawyer or a politician at all. You've done more than any lawyers and politicians could ever do. So thank you for that, and all of you. I was very focused on this issue from the beginning when I came into the White House in 2009 because of my own experience in the field. And I'm sad to have been nodding my head while Kathleen was talking, because sometimes I feel like not much has changed. I think what Dylan was talking about practices with kids has changed a lot. What those mental health professionals do. I run a center today where we do forensic interviewing and medical care for sexually abused kids. And I believe that work has really progressed to protect children. But that's just a part of this. This was on my radar from the beginning. And I remember, as Kathleen said, about the protective moms who came in to see me in the White House. And I remember Amy Lickenberg in particular, and her two little boys, Duncan and Jack, who were killed by their abusive father when he was granted unsupervised visitation, in spite of many indicators of risk. And when I was at the White House, I kept Jack and Duncan's picture on my desk for a long time because I wanted to remember them. Because we did really struggle at that time with what was the federal lever to pull to improve state courts. And I was very focused on the preliminary research, which now we know even more about custody evaluators and all these court-appointed professionals who really didn't know much about domestic violence and child sexual abuse. And I was very focused on this research that showed that those custody evaluators didn't review evidence of abuse even when it was in the file. And I had a lot of experience working with guardians ad litem in the field, and also knew that they were not often well-versed in domestic violence. And so I was very concerned that judges depend on the opinions of all of these people who are often not competent or capable of making those recommendations. And we can't assume that the mental health profession understands the issue of domestic violence or child sexual abuse. And I think of, in Dylan's case too, how you were failed by a lot of mental health professionals. So it's this whole, it's this entire system where we see this lack of competence. So what we did in the Obama White House is we pulled together an interagency work group of folks at Child Support Enforcement, Child Welfare, the Justice Department, Office of Victims of Crime, And we did really struggle with what's the federal lever to make change. And what we settled on was asking Congress to create a program in VAWA 2013, which they did it's called, I think today, Justice for Families. And it was focused on improving court processes and providing training to all of these court-appointed professionals, in particular noted in the statute, are custody evaluators and guardians ad litem. And then among other kinds of purpose areas, communities could apply to provide legal representation for victims of domestic violence and to create supervised visitation programs. So that was our initial effort in this area. And I think it was important, but I should say I was insufficient. And I'm very glad to hear that federal efforts have progressed quite a bit since that time, because our gap really was in what the policy levers are at the state level. And I think we're going to talk more about this on that panel. But I do think that this VAWA program, putting this grant program in the Violence Against Women Act, made a difference, because VAWA is the organizing principle for states and local communities in addressing domestic violence and sexual assault. And the program has trained more than 10,000 of these custody evaluators and guardians ad litem and other court-appointed personnel. And I think that's critically important, but I'm excited about what's happened since that time with additional federal remedies. I also am acutely aware now, because I'm working at the local level, that there's a big gap between what federal policymakers intend when we work on legislation like the Violence Against Women Act and how states and local communities interpret that. So I'm very interested in continuing to work more on that effort.
I think you've really put your finger on some really important pieces that are part of the problem, and that would be judges that don't necessarily have any special training in domestic violence or child sexual abuse, but especially when they occur in a context between two parents. And then the judges are really listening to these court-appointed professionals, custody evaluators and guardian ad litems and CASA volunteers to really try to make a decision, and they're not trained either. And it sort of has created a perfect storm on the ground in these types of cases. So I think you've really highlighted some things, both that are a big part of the problem, but also some things that should be focused on in terms of reform. Senator Min, you've actually are working on that type of reform at the state level, and you've authored an important child safety bill in California this past session to better protect children of divorce and separation during unsupervised visitation with a parent that had a history of domestic violence or substance abuse. You ran into some unexpected obstacles, I understand, in passing this, what is a pretty straightforward bill. Maybe you can talk a little bit about that and why you think you ran into some opposition there.
Well, thanks so much for the question, Camille. And, this is a vexing problem, and, children's needs, their safety is too often overlooked. And here in California, a lot of folks, think we're a progressive state, that we don't have these problems, but we clearly do. Many judges, as has been described by Lynn and others, just kind of take that discretion they have and act in ways that don't really have the interests of the children in mind. And this came to a head in Sacramento, actually, not too long ago, with the murder of Sarah and Sophia. I think they were 9 and 12 by their father. And their father was someone who had a long history of violent threats, of domestic violence and abuse, who had actually threatened to kill the girls. And yet the judge awarded unsupervised visitation, even though that same father was not allowed to have custody because of his violent past. And so what SB 654 tried to do was just to harmonize the law around unsupervised visitation with the same standards that we use for custody. That is to say, if you have a history of abuse, history of violence, that should be something the judge has to consider. And if they're going to award any kind of unsupervised visitation, they have to make a written finding to the contrary. I think that bill encountered some opposition just because there are people who thought that didn't go far enough. And I actually empathize with that viewpoint. There were a lot of advocates who wanted that bill to actually force judges to deny unsupervised visitations in all contexts if the father or the abusive, I guess, parent had any history at all of drug abuse, violence, or anything like that. We did not have the votes. We knew that that bill we were told, far too aggressive in trying to get across the finish line. And so we thought this bill was something that could get through, that would actually meaningfully address a lot of the problems that we face. And the reality that we're all describing here, and I think Lynn hit on the head, it's tough to get from the federal level down to the local level. It's also hard in a state the size of California to try to dictate policies that actually trickle down into our individual courts in ways that we mean to. But we think this particular bill will force judges to take that step of saying, you know, if I'm going to deny, or if I'm going to allow unsupervised visitation, I have to go on the record as to why I think this is appropriate. And we think that step will cause judges to act appropriately in actually considering the safety of children. So in our mind, this was about balance. It was about getting progress and a meaningful step in place. And we could not have done this without Kathleen's help and the help of her organization, Center for Judicial Excellence, which helped us think through a lot of the policy around this, but also a lot of the politics. And, you know, we talked, we consulted with attorneys, legal experts, parents around the state. And we knew we had a problem. We wanted to fix that problem as much as we could this year. And we do know SB 654 could have gone further, but we think this is a good first step that will effectuate real change. It will save lives. But at the same time, we hope to continue working with CJE and others to try to keep moving that ball forward so that we can get some of the other changes that the advocates really want. And so we're hopeful, you know, but it all takes time. Progress takes time. And so we think this bill was worth doing.
Well, I know that everyone's incredibly grateful that that you're out there working on this type of legislation and taking the lead. I also know that it can be frustrating for advocates. You know, they want to see everything done all at one time, but it's important to remember not to let perfect be the enemy of the good. So, you know, incrementalism is an important step, and it's must be tough to bring around, you know, all of your colleagues into the issue as well. Dylan, I understand that you played a role in helping Senator Min pass this legislation this past summer. Can you talk a little bit about what it feels like on a personal level to turn your trauma into transformation and to help improve the lives of other survivors by getting involved in advocacy?
Again, it's a very loaded question. Basically, I mean, I am fortunate that I have a platform, and I was very, very happy to use that platform to boost the signal of Senator Min's incredible work. And again, it's a wonderful stepping stone in seeing progress. And it's in terms of, you know, trauma, it does help to feel like I'm active in playing some sort of role in bringing about transformation, not necessarily for myself, but for other kids and for other survivors. That can be an important healing step. And I mean, it's also very, very difficult because the trauma is still there. The trauma doesn't necessarily vanish into transformation. It's you know, it's a changing, shifting process that a lot of people are working through, and I really hope that that progress can continue to be made.
Well, thank you for all your efforts to continue to, you know, put yourself into the fight. I know everyone's very appreciative of it. Lynn, it's taken a few decades, but the protection of children in family courts is starting to make its way into federal legislation, which is a really great point of progress. In 2018, the House passed Congressional Resolution 72. Cadence law has been included in the House passed VAWA. We're hopeful it'll stay included in the Senate version as well. And there's language that showed up in the House Appropriations package that would fund a study on custody outcomes in cases just like Dylan's. That was included by Congresswoman Norma Torres from California. So I guess the question is, given your years of experience working in federal government, can you talk a bit about this recent progress on these national issues affecting child survivors in the US, and why are these studies like the one that's put into the House Appropriations package necessary, and what are some possible next steps?
I think this does show a tremendous amount of progress, and I think that these efforts really find the piece that we were missing when we first started on this in the Obama administration, and that is how you identify the federal levers. And there's others too as well. I think the government research is essential to creating public policy. And this will build on the work of GW Family Law Center, which did an analysis of 2,000 court opinions and found the skepticism of mothers' claims of abuse. But to have that kind of research done by the federal government, for them to carefully analyze that and then be able to make recommendations to policymakers is critically important. So I think this is the next level that builds on what we did in VAWA 2013. You know, that program really funded direct services and training and legal representation, but this will, Caden's Law in particular, really focuses on policy, and that policy change is what's necessary. There were two things that stood out to me in the work that I was doing on this. I actually found, Kathleen mentioned sort of the effects on this issue and how parental alienation is also in play in the child welfare system. I actually found a child welfare manual, which I'm sure was one among many, and I don't even remember what state it was from, where child welfare workers were trained to view with skepticism claims of domestic violence and child sexual abuse when a divorce was in progress. Trained to do that. And so that were from that was 10 years ago, that were from that point to these sort of federal policies that will bring to light additional information that then policymakers can use to create additional change, I think is critically important. We also noted that the data that showed that when states have friendly parent statutes, even when they had domestic violence protections in their custody laws, the friendly parent statutes kind of won the day. And so this sort of levels that playing field. We'll see what comes out of these government studies, but I think we already know from the research that's been done by GW Law, Joan Meyer, and others, what they're quite likely to find, and that is this whole continued and ongoing crisis in the family courts. So this kind of policy approach is what's needed. And I think all the direct services that we're funding under VAWA and the legal representation is critically important, but working one family at a time, one survivor at a time is not what's going to solve this problem. It's really the policies that are going to solve this problem. So I think it's great progress. I really commend everybody that's been working on it. And I do think that issue of how you get from federal policy to state and local communities remains critically important. I don't have the answer to that, but I know I'm sitting here in Columbus, Ohio, and I listen to local policymakers talk about these issues. And, you know, I helped provide technical assistance to Congress in writing much of the Violence Against Women Act. And then I hear it talked about in a way that is not at all what we were intending when we worked on the language. So I want to urge the national advocacy groups to be very cognizant of that and to consult with state and local communities in drafting federal legislation, that you really want to know what's the state struggling with, what are the policy steps that would be useful for them in implementing an agenda like this, and making sure that we are creating those linkages between federal policy, state, and local community practice.
It sounds like what you're describing too is an actual baked-in bias. You know, if social workers are being trained to actually be skeptical, then it's just creating this sort of circle of confirmation bias within the system itself, which is probably adding to some of the confusion and creating an actual systemic discrimination that impacts children, because they're being discriminated against based on the relationship between their parents, and that their abuse allegations are not getting the objective type of investigation that is warranted, no matter what the status of their parents' relationship is to each other. So it sounds like we have some institutionalized discrimination there that you're describing. Senator Min, you also spent some time in the federal government, and now you're a leader in the California legislature. Senator Susan Rubio, you worked with her on protecting domestic violence survivors. And it seems also you and your wife are sort of a power couple there. Jane Stover, who we adore, is the leader in fighting for survivors through her leadership at UC Irvine's initiative to end domestic violence. Do you have anything to add about the importance of having reliable data when crafting policy reforms, especially those in another branch of government that's not particularly welcoming when it comes to asking them to reform themselves, like the judiciary or law enforcement?
Sure. And I should first say that I give all the credit to my wife here. I do not do domestic violence. My background is in banking and economics. Jane, Professor Stover is, I think, doing some really groundbreaking stuff. And Lynn, I know she had the honor of meeting you in the White House with a small group of law professors to advise on domestic violence policy. And she thought it was just blown away by what you're trying to do. Jane also actually recently traveled to Washington to meet with different legislative leaders and the White House with the actor and activist Angelina Jolie. And so she's kind of been pushing on this, but I would say, speaking for her and just more broadly speaking for the legislature, I think it's key that we have data-driven policy. That's true of anything we try to do. We can have our theories and our ideological presumptions, but ultimately, if it's not working at the end of the day, in this case, to keep survivors safe and families safe, then it's not effective. And so we have to constantly be trying to reinvent the wheel. We have to be trying to improve and reform what's already on the ground and think about what else needs to happen to keep survivors and their families safe from family violence. And the only way we really can do that is to have that information, that data on the ground. So I really am heartened by the fact that it seems like there's a growing consensus that we do need to collect, aggregate, and then analyze that data. And so just for example, on SB 654, we wanted to understand why judges had to take precautions before placing children in the custody of abusive adults in unsupervised visitations. When those, why do we do that for custody, but why do we not do that for unsupervised visitation? The data did show us there's a real problem. A 2011 study by the National Institute of Justice found that 47% of custody evaluators continue to recommend unsupervised visitations with a parent, even when there were reports of violence in that home. Why is that happening? And why do we have to go back to 2011 report to come up with that data point? Another national study showed that many child homicide victims are murdered by a separating or divorcing parent during court-ordered unsupervised visitation with the murderer, despite the fact that the court typically is presented with evidence of that history of abuse and threats to harm the children. So in this case, the data was instrumental in us proposing the legislation and then in trying to rally my colleagues because all they care about is data too. Why is this necessary? What is this going to do? Why is this actually going to work? Those are the types of questions that legislators and policy folks, whether at the local level, state level, or federal level, all feel like are critical because we want to implement solutions that work. So, just echoing the comments that Lynn made, we need data-driven policy. We need to take a really comprehensive approach to figuring out how we can collect that data.
Yeah, it sounds like there's probably an uphill battle if you don't have, especially recent data that you can point to in terms of all these various places that you're going to want to write policies to reform it. Kathleen, the Center for Judicial Excellence has gotten some historic audits of the family courts in California, which is fueling a possible overhaul of California's Judicial Oversight Agency in 2022. What have you seen are the biggest barriers to reforming the family courts at either the federal or the state level?
Yes, Camille, thanks. The center has a key part of our mission is to increase judicial accountability. And we realized early on the importance of having data. And yet the courts have consistently kind of refused to track the outcomes of these family law cases, in part because they'll highlight just how broken the system is. And it's quite a big undertaking to fix it, as we've seen over the decades of trying to do that. But we've made good use of the California State Auditor by securing multiple audits to provide data and recommendations to the legislature, which has helped legislators feel more comfortable. This past session, AB 1577 from the Assembly Judiciary Committee itself creates a new committee to review the operations and structure of the Commission on Judicial Performance, which is California's only judicial oversight agency. This new committee, which includes public members in addition to CJP staff, will convene public hearings and will report to the governor and the legislature by March of 2023 about the reforms that they're recommending from the 2019 state auditor's report on the CJP. And just this took 3 years to get this audit done, and the state auditor was sued by the CJP to try to stop the audit. And yet this audit is now going to be the focal point of this new committee. And to give you an idea, one piece of the audit found that there was a complaint against a judge who threatened to assault a litigant from the bench, and it was not properly investigated. So these are not gray area or minor issues of judicial bias that are being missed by the oversight agencies. It had never been audited in the 61 years that the CJP's been around. So back to your question though, I believe there are three of the biggest barriers to court reform are one, a legislative hesitancy to interfere with the co-equal branch of government. We've heard this time and again at the federal and state level. I know at the federal level, it's also been a jurisdiction issue, which Lynn referred to, but federal funding does flow to state courts and judicial councils. So there are ways to approach this federally, and as we have with Cadence Law with our colleagues. There's secondly, a tendency for legislators and lawmakers to dismiss the horrific outcomes as just like really bad outliers to minimize the extent of the crisis. It's very difficult for folks in government to believe how many of these harmful outcomes are happening and that they're as widespread as they are. So there's a bit of denial or just hard to wrap your head around it. And then third, the judicial branch just has a tremendous amount of wealth, power, and I'll say it, cronyism. A lot of adult victims in these cases are bled dry of their resources, they're gaslit, they're run into the ground. The child victims are rarely heard from. And the branch commonly over decades dismisses complaints as just coming from disgruntled litigants who should appeal their decisions. So we've kind of asked repeatedly, how many disgruntled litigants will it take until we can reform the system to better protect these children? So that's kind of where we're at.
Thank you, Kathleen. Dylan, back to you. You have this very unique perspective here on this panel, especially because this is something that you actually survived and went through. And I'm wondering, you know, we're going to have a lot of congressional and state legislative staff listening to this panel, and I'm wondering if there's anything, if there's anything that they could do to help child victims as they're going through that process. Is there any takeaways for them that they may be able to put into some type of change for child survivors?
Well, I mean, first of all, just, you know, listen to us. Listen to what we're saying, you know, take into account the fact that, you know, this is a very traumatic thing, not just the abuse, but also disclosure is incredibly, incredibly difficult. I think, you know, instead of, you know, maybe the knee-jerk reaction to, you know, verify, triple fold, you know, just listen to children, take what they say, you know, at face value, because kids don't lie about this. They really don't. And, you know, cases of, you know, coaching is so abysmally rare that, you know, I really hope that anybody who's listening isn't, you know, feeling doubtful but for reasons of, you know, parental alienation or, you know, buying into, you know, that sort of conspiracy theory mindset that there's, you know, a evil puppet master looming over these children's shoulders. A lot of them just want to be, heard, believed, and then go about their lives. If we can make it so that children don't have to relive this over and over and over, I think the children will be very thankful for that.
I'm going to improvise one question here. How important is trauma-informed therapy for children that have survived child sexual abuse?
I'm a huge fan of therapy, of good therapy. But finding a therapist that you can trust, that is helpful, is key. It's been key for me in helping me sort of unpack everything. And I feel like that came to me a bit late in life. I wasn't really sort of, as a child, very aware of the benefits of therapy. I wasn't sure exactly. I mean, because I've been in therapy since I was 6. So you can't really explain that to a 6-year-old, like, this is to unpack your trauma. That they don't get that, they don't understand that they're, traumatized. They can understand that something's wrong, but I feel like good therapy is there can't be enough of it. And I definitely would say that it would be important for these kids to, have that.
Yeah, it sounds like maybe one of the reforms that for staffers that are listening, one of the reforms would be to invest in building capacity amongst clinical psychologists so that they can increase their ability to provide care for children that have experienced trauma. So that's definitely something that can be accomplished through policy and through appropriations. Senator Min, this is sort of our last question here. What is next on your radar for bills to address the child abuse crisis and domestic violence crisis in state courts?
Yeah, so we're working on a package of bills that we're hoping we can put together as almost like a domestic violence child safety omnibus this year to try to continue the mission of removing obstacles to justice and creating robust safeguards for survivors of abuse. One of those bills will be around coerced debt and trying to provide relief to survivors of domestic abuse who have been forced to take on by their abusive partners debt of different kinds, so that they don't walk out of that relationship with tons of debt they can't pay, with a credit score that's ruined. We know that's a barrier to people, often women, leaving these types of relationships, is just the financial implications. We're also looking at expanding the scope of the domestic violence death review teams we have here in California in each county to also encompass near death experiences, because that is a much bigger number. And if somebody's at the point where they're almost dead, we feel like there's an important role for the state to intervene and investigate what happened there. So stay tuned. We're still kind of finalizing what we're doing. And if you have any ideas, we're open to them. But this will again be a primary focus of what we're trying to do in the state. We certainly, again, will be partnering with Senator Rubio on a lot of this stuff.
That's terrific. I'm just going to do a quick wrap up and then ask anyone to jump in and add anything I might have missed. It looks like there's a lot of opportunity for policy reform and also some appropriations and budget items here. It sounds like we need specially trained judges and specially trained court personnel like guardian ad litems and custody evaluators, and even social workers and CASA volunteers need to have some specialized training, especially on these types of cases where there is an issue around divorce or custody as when the allegation arises. It also sounds like we need a lot more recent research. We need research on the performance of the states, their courts, how many judges are supporting petitions for protection when they are filed either by a litigant or by a state actor like a Child Protective Services social worker. I think it would be really interesting to look at data, how often judges are declining protective orders or removal orders in cases where the state, like Child Protective Services, has actually taken a position. And then that leaves the protective parent with no option but to advocate for themselves, and they're sort of left out twisting in the wind, and they're up against the ropes at that point. So it sounds like we have some real need for some more recent research about how the state courts and court personnel are actually performing their jobs. And it sounds like we need some lots of funding for additional therapists that can provide very competent trauma-informed care for child survivors and domestic violence survivors. Is there anything, I want to open it up to the group before we sign off, is there anything that you feel like I missed or that should be added?
I wanted to address this, put back on people's radar, unified courts, one judge, one family in domestic violence and child abuse cases. And I think there are some good models around the country to look at and see what we think about that data. Two is there are other places in the federal code. I started this project, but wasn't able to finish it when I was in the White House, where we could tie prohibitions on the use of junk science like parental alienation to other kinds of funding conditions in child welfare and court. So it's looking at federal funding levers where we can push forward. And then the third thing I wanted to say is just to advocates who might be listening that change is slow. You've just heard what it's taken 10 years or more to do, but stay with it. That advocacy is essential, and it may take some time before you see the results, but they are coming. So just hang in there and stay motivated. And thank you, Dylan, for doing just that.
Yeah, and I'd love to also let Dylan know that our movement of family court reform survivors is so incredibly grateful to you for your courage to keep speaking your truth for decades in the shadow of an incredibly powerful and influential father. You continue to be an inspiration to millions of survivors worldwide, especially after this incredible HBO miniseries, which I know was not easy and took a lot out of you. And we just really want to thank you for your inspired leadership. You are the change. You know, we can't make progress without survivors at the helm. So also want to thank Senator Min and other state and federal lawmakers who've shown real courage and leadership to wade into these policy waters, which can be choppy. We need to keep forging ahead, keep shining a light, keep bringing these stories to the people who can make change happen. And panels like this are crucial for educating policy staffers that this can and must be dealt with, especially if your bosses are committed to child protection, fighting poverty, and increasing access to justice. And thanks to all of our panelists.
Oh, you're on mute, Senator Min.
I just want to say thank you so much for having me, and thanks for all the incredible work that you all do. I'm in awe of not only Dylan, who we know is out there on the front lines, but Lynn, Kathleen, your work in this area is really inspiring, and I hope to be able to try to continue interacting with you all and seeing what we can do here in California to try to advance some of the work that you're doing.
And likewise, I just want to thank you all and for all the work you do. I feel like I learned so much today from all of you, and I really look forward to taking that and keep on fighting onwards with it. So thanks again, and I'm just very, very grateful, and I can't express that enough.
Oh, well, thank you for joining us, Dylan, Kathleen, Senator Min, Lynn. It was terrific to see you. All of you had incredible insights and really valuable information. And we're looking forward to getting this panel in front of as many staff and members as we possibly can. So thank you for joining us today.